Where is the voice of the people of Jammu and Kashmir? Where is the voice of representative democracy? 5 years have passed. Have you heard, Mullahs? Any representative form of government? You convert a whole state, Mullahs, this way all of India can be converted. This power is given. And Mullahs, the proviso said you have to take the consent. You do away with that through an executive act. You don't even take their views. You become the legislature yourself. So where do we stand, Mullahs? We stand at a situation where, Mullahs, though the Constitution is a political document, its provisions can't be manipulated and maneuvered for political ends. It cannot be. That's not how you interpret a Constitution. It is a political document, but you cannot politically misuse it and maneuver it and manipulate it, which is what has been done. That can't be done. And even when there is a clash of arms, the law is never silent. The law is not concerned with that. The court is never silent. And whenever the court has been silent, the consequences have been disastrous. It's time for your lordships. And what is a constitution? A constitution is a set of values. Values on the basis of which people will represent themselves and their voice will be heard. If you, through such executive acts, silence the voice of the people, what is left of democracy? I don't see the silence in that proviso where the perpetuity of a presidential notification can be issued at any time, even after even.
So, the two plain consequences of your submission are: first, once 370 clause 3 goes out of operation for all intents and purposes, 371 and 2 have a permanent character in the Constitution.
2 is not there, Manas. 2 is not there.
Right, 2 is, of course, yes, after the Constitution.
Yes.
371 has a permanent character in the Constitution. Correct. Second, you cannot amend 370 using the 368 power because of the restraint which is imposed by the proviso, which again takes you back to 370. Therefore, even the power to amend 370 is within the fold of 370 and not 360.
Let me answer that also straight away, Manas.
So we are carving out really a provision of the Constitution which lies even higher than the basic features.
No, Manas. That your lordship should not say, Manas, because that's not yet tested. That your lordship should not say, that's not tested yet. Whether it's higher than the basic feature of the Constitution or not, Manas. But kindly see, this was added in the 1954 order, Manas. The proviso to 368(2) was brought in by the order, as well as, Manas, the proviso to Article 3 in 1954. Who brought it, Manas? The government of India. State of Jammu and Kashmir did not. They gave its consent to it. Why did they do it? Because they did not want 370 to be tampered with. I am not saying this, Manas. I am talking of the intent of the government of India. And the proviso was added both to 3 and 368. Not my intent. And your lordships are now saying, what is the intent of the government of India? It was made clear that even under 368 you can't do this. Government is a continuum. Kindly, Manas, appreciate that. It is not something that was done by Jammu and Kashmir on their own. I understand, Manas, and there we go into the sentiment argument, the emotive argument. The argument that Mr. Dwivedi made with respect. That we appreciate the sentiments of people of Jammu and Kashmir, but there are sentiments in India. Whereas with the greatest respect, I humbly pray that we are dealing with the Constitution. It's a sentimental thing. I also have sentiments with a lot of things. But when we come to court, we discard do away with what our heart, the nature of our heartbeat, and come to brass tacks and interpret the Constitution. You can pepper it with emotive instincts, but you can't get away from the plain language. And my respectful summation to your lordships is, a political process must have a political solution. And as I said, what is left of 370? There is no residuary power with we talk about residuary. What is the residuary power? There is no residuary power with the state. When did the state ever exercise residuary power? So for all intents and purposes, it is fully integrated.
In other words, according to you, there is no solution to Kashmir within the Constitution. devise a solution outside the
Why,
constitution.
now your lordships are putting this to me.
Ultimately, that's
No, that's not what I have argued.
that's the hypothesis, that the solution has to be political outside the constitution.
It is a problem looking for a solution, and your lordships don't have to provide that solution, is what I'm saying.
All solutions have to be within the framework of the constitution.
It is within the framework, Manas. It is within who says it's not within the framework? Well, isn't 370 a classic form of federalism? Unlinked to the federalism that we practice? It's a classic form of federalism. There's nothing unconstitutional
There
about it.
can be a lot of arguments on the other side. Let's not go into all that, whether
No, I'm just saying, I'm saying, Manas, it is not unheard of. It is not something that is so utterly unthinkable that a state can have a certain special status.
if you go by Dr. Ambedkar's adoption speech, it's quite clear that he wanted a unitary form, primarily unitary form with certain federal
It
features.
is unitary, Manas. Who says it is not
That's
unitary?
very clear, and there's historical
Manas,
reasons. And let's not go into the
Ambedkar said an also very important thing. Way Jammu and Kashmir. He said that, no, that's not what he said. That equality is in your mind. The equality, all people in this country are equal. Some are not considered equal. That's all. That applies not just to Jammu and Kashmir, that applies to a lot of places in India. So let's not go that route. Well, just because it's a union doesn't mean we are not federal. We are a quasi-federation is what we are. And that's what Ambedkar said, that we are a quasi-federation. But Manas, quite apart from that, that's how all members of parliament since 1950 have understood it. Manas, why are we? That's not their case. We are trying to find a solution, which is not the case of the Union of India.
Sibal, Dr. Ambedkar in his speech, both speeches, 4th of November 1948, as well as 25th of November 1949, he has distinguished the American Federation with our federal structure, and he has specifically said that in America, there is a citizenship of the Federation as well as the state citizenship, and it permits two constitutions, the state constitution as well as the federal constitution. Correct. But in India, we have adopted a single constitution and single citizenship.
Absolutely. Right, Manas, but kindly look at it this way. It is this Constituent Assembly that approved 370, of which Ambedkar ji was a part.
So therefore, the question will be whether it was a temporary measure.
No, this is what the Constituent Assembly said. This is what Manas, the cabinet said. This is what the government said. This is what the government has been interpreting 370. This is what they have done, Manas, in the light of the interpretation of 370, as we have placed it before your lordships. What is 272? To replace the Constituent Assembly with the Legislative Assembly. That is trying to implement the proviso, no? They've used the proviso. Now they are arguing just to the contrary. How can your lordships even allow them to do that? We are testing, Manas. We are testing the process. We are not testing the power. We are testing the process. And the process adopted by them is the 370 sub-article 3 process. They have substituted Constituent Assembly to Legislative Assembly. Then they have imposed 356 and Parliament has become the Legislative Assembly and given consent to itself. Plenary power or any silence in 370 which allows them to do what they wanted to do. That's not their case. So we are now adjudicating a case which they have not pleaded before your lordships. If a private citizen were to do that, would your lordship ever allow it?
Mr. Sibal, you are saying 373 doesn't exist practically. Correct? That's your argument. Their argument is 373 exists and we've taken that.
No, they say 370.
That's the second part. Whether the process applied by them under 373, if it exists, is the proper process as per 373 or not, is the second limb of the...
But I'm saying something else to your lordships. They proceed on the basis that 370 exists.
Correct.
Therefore, they are not saying that 370 doesn't exist after the Constituent Assembly was drafted and nothing else happened and there's no Constituent Assembly. It's not their case. We are now, we are now adjudicating upon a case which is not the case of the Union of India before your lordships.
Many things have been said, Mr. Sibal, from both sides which are really not, in our view, prima facie germane. The main issue is this of 370, as you say, one side of the argument that with the Constituent Assembly going away, 373 really did not subsist, only 371 survives. Their view is that 373 subsists and that's the route we have adopted. Second limb arises if 373 exists and the route they have adopted, what's the correct route permissible or not?
But that's what I'm arguing. When I opened, I only argued on the route. If your lordships remember, I never went into any political argument, any historical context.
So that is your argument that
I never talked about lack of sovereignty. I never talked about federalism. I never talked of any of that. I said this is the process they have adopted and this process is unconstitutional.
I remember you also said that it's not for us to, or for you, or to suggest what is the alternative.
Exactly.
Then when the alternative route is followed, it will be tested in its own way.
Correct.
This is the route they have adopted.
And
They've
that-
not taken a 368 route.
That's
They've taken
correct.
a 373 route.
So the first question that your lordships have to answer is 272 valid or not? And
That will have to decide.
Yes, and that can't be decided. That can't be decided because that they have followed the route of 370 proviso, Malad. It is their case.
Yes, yes.
So the problem there with the argument is that 370 can't be decided in the context of the argument now raised. That after the Constituent Assembly is not there, we can do what we like. But that's not what their case before the court is. Their case is that they have applied the proviso and substituted Constituent Assembly for Legislative Assembly.
That's what the CO says.
That's right. So you have to test only that, which is what I argued. I didn't argue anything else.
We are not asking you to argue beyond it.
No, they have forced me to argue beyond it. They have forced me to argue beyond it. But let me go back a
Even
little.
assuming that they have followed the route of the proviso to 373, I don't think we can prevent them from sustaining the exercise of power on the ground that even independent of that we are entitled to.
That's not in their counter. I'm sorry, Malad, that's not their case.
Just my.
I'm sorry, you read your counter.